Understanding the scope. What business are you really running? As we transition into Chapter 2, the focus shifts from structure and systems to the actual nature of the business being conducted. The Broker Audit Declaration, BAD, requires brokers to clearly identify the types of real estate activities their brokerage performs. This is not just informational, it directly impacts regulatory expectations, supervision requirements, and audit risk. Under AAC R4 to 28-1103, the designated broker must supervise all real estate activity within the brokerage. However, the level and type of supervision required depends heavily on the nature of that activity. A brokerage focused solely on residential resale operates very differently from one managing rental portfolios or handling commercial investments. ADRI expects brokers to not only disclose their business types, but also demonstrate competence and control within each category. This ties directly back to Chapter 1. Your systems, structure, and transaction volume must align with the type of business you conduct. If they do not, risk increases significantly. Residential sales versus property management, two very different worlds. Residential sales are the most common form of real estate activity in Arizona. These transactions are typically standardized, utilizing forms such as the AAR Residential Resale Purchase Contract, and involve a defined beginning and end, listing, contract, escrow, and closing. Property management, on the other hand, is ongoing and far more operationally intensive. It involves handling tenant funds, managing repairs, maintaining records, and ensuring compliance with landlord-tenant laws. This introduces a higher level of fiduciary responsibility. Under ARS, paragraph 32-2173 and paragraph 32-2174, brokers engaged in property management must properly handle client funds, maintain trust accounts, and follow strict accounting procedures. Unlike a one-time sale, property management creates continuous exposure to risk. For example, a brokerage in Mesa that handles residential sales may only need to manage earnest money deposits during a transaction. However, a brokerage in Phoenix managing 200 rental units must track rent payments, security deposits, maintenance expenses, and owner disbursements on an ongoing basis. The level of supervision required is significantly higher, and ADRI will expect systems that reflect that complexity. Commercial brokerage versus leasing, increased complexity and risk. Commercial real estate introduces an entirely different layer of sophistication. These transactions often involve customized contracts, extended timelines, and higher financial stakes. Brokers must understand concepts such as cap rates, tenant improvements, CAM charges, and lease structures. Commercial leasing, in particular, can present unique challenges. Unlike residential leases, commercial leases are highly negotiable and often contain complex provisions that require careful oversight. Misunderstanding or failing to properly supervise these agreements can lead to disputes and liability. A relevant case that highlights the importance of broker knowledge and duty is Morley v. J. Pagel Realty and Insurance, where the court emphasized the broker's duty to act in the client's best interest and provide informed guidance. While not specific to commercial leasing, the principle applies. Brokers must understand the transactions they supervise. For example, a Scottsdale brokerage handling retail leasing in a shopping center must ensure that agents understand lease terms, escalation clauses, and tenant obligations. If agents are operating beyond their level of expertise without proper supervision, the broker may be exposed to liability under ARS, paragraph 32-2153. Subdivisions, timeshares, and specialty niches, high regulation areas. Certain types of real estate business carry heightened regulatory requirements. Subdivisions, timeshares, and other specialty niches are heavily regulated by ADRI and often require additional disclosures, approvals, and public reports. Under ARS, paragraph 32-2181 and related statutes, developers and brokers involved in subdivisions must comply with strict disclosure requirements, including obtaining a public report before marketing properties. Timeshare sales are governed under ARS, paragraph 32-2197 and require compliance with specific consumer protection laws. These types of transactions are not only complex, but also highly scrutinized. Brokers must ensure that agents involved in these areas are properly trained and that all regulatory requirements are met. For example, a brokerage in the greater Phoenix area assisting with a new subdivision development must ensure that all marketing materials align with the approved public report. Failure to do so could result in significant penalties and potential suspension of the broker's license. This reinforces a key concept. Not all real estate business is equal in the eyes of the law. Some areas require significantly higher levels of compliance and oversight. Disclosure of business types to ADRI. Transparency is key. The Broker Audit Declaration requires brokers to disclose the types of business they conduct. This disclosure is not optional. It is a foundational element of ADRI's oversight. Why does this matter? Because ADRI uses this information to assess whether the broker's systems, supervision, and experience align with the activities being performed. If a broker indicates they engage in property management, ADRI will expect to see trust accounts, management agreements, and proper accounting systems. If a broker reports commercial activity, ADRI will expect evidence of competency and oversight in those transactions. Failure to accurately disclose business types can be viewed as a form of misrepresentation, potentially leading to disciplinary action under ARS, paragraph 32(2)(153). For example, a brokerage that primarily conducts residential sales but occasionally handles property management without proper disclosure may face issues during an audit. ADRI may question whether the broker has the necessary systems and knowledge to manage those activities. Transparency is not just about honesty. It is about aligning expectations with reality. Bringing it all together. As we move deeper into Chapter 2, it becomes clear that the type of business you conduct defines everything else: your systems, your supervision, your risk, and your compliance obligations. The Broker Audit Declaration captures this information so ADRI can evaluate whether your brokerage is operating within its capabilities. In the next section, we will build on this foundation by examining trust account requirements, arguably the most critical and heavily regulated component of brokerage operations. Online discussion. Why does ADRI require brokers to disclose the types of business they conduct? Answer. ADRI uses this information to assess whether the broker has the appropriate systems, supervision, and competency in place. Different types of real estate activity carry different risks, and disclosure allows ADRI to evaluate compliance accordingly. How does property management create greater risk compared to residential sales? Answer. Property management involves ongoing handling of client funds, tenant relationships, and financial accounting, which creates continuous fiduciary responsibility and higher potential for trust account violations. Why are subdivisions and timeshares considered high-risk areas? Answer. These areas are heavily regulated and require strict compliance with disclosure laws, public reports, and consumer protections. Failure to meet these requirements can result in significant penalties and disciplinary action.